The America's Democrats podcast, a project of 21st Century Democrats, is made possible by contributions from our listeners. Want to do more? Go to americasdemocrats.org and click Donate. And thank you for allowing us to be your voice. And if you enjoy the show, please share it with your friends on Facebook and Twitter, and leave us a review on your favorite podcast app. This is the America's Democrats podcast, the weekly podcast for stand-up Democrats. I'm your host, Jim Cuddy. This week, labor law scholar Alexander Colvin explains why a recent decision on arbitration will have far-ranging impact for workers' rights. Nicole Porter of the Sentencing Project tells us why at least 6 million Americans are denied the right to vote. And Bill Press talks with Sam Baker from Axios about what's coming up next at the Supreme Court and another setback for affordable health care. Had enough of Fox News, the House Freedom Caucus, and Donald Trump? If you want the facts that you won't get from them or from the fake news sites of the alt-right, then stay tuned. Our sponsor, 21st Century Democrats, works hard to get everyday Democrats involved in returning our party to its roots and to success at the ballot box. Sit back and listen, then stand up and fight. And follow 21st Century Democrats on Facebook for all the latest progressive news. We're glad you can join us. Alexander Colvin is one of the nation's foremost experts on workplace arbitration. He says that the recent Supreme Court decision to deny the right for employees to engage in class action lawsuits is backlash on steroids to the movement for workers' rights. And we say hello to Alexander Colvin, professor of conflict resolution at Cornell University's School of Industrial and Labor Relations. Alex Colvin, thank you so much for joining us today on the America's Democrats podcast.
Thanks for having me.
Well, our pleasure to have you with us. Now, the Supreme Court recently made a decision on workplace arbitration. It's called Epic Systems Corporation versus Lewis. A little quick kind of synopsis background on that, and then what did that decision say?
Sure. This is one of those decisions that I think came under the radar for a lot of people. Mandatory arbitration is something that's been going on for a while, where employers require a worker to sign an arbitration agreement as a condition of getting a job. And so if you want the job, you have to sign the agreement. And what the agreement basically means is any legal claim, you can't go to court anymore. You have to go to this private arbitration forum. People didn't pay, I think, a lot of attention to it, but what Epic Systems says is that arbitration agreement can now prevent you from filing a class action. So you put in something called a class action waiver, which says, I agree, I'll only go by myself individually to arbitration, and I can't bring a class action anymore. And what the Supreme Court said in Epic Systems is that provision in the mandatory arbitration agreement, that's enforceable.
Now, this is being called a big win for employers. Why?
Absolutely. It's a huge win for employers. Essentially what it gives employers is almost a get-out-of-jail-free card to avoid class actions. So the deal is that you can't go to court with a class action because you've signed a mandatory arbitration agreement. That means you have to go to arbitration. So no class actions in court against the employer. And then this says that you can't even do the class action in arbitration, which is the form you have to go to. So there's really no way effectively to bring a class action or a collective action for a bunch of employees acting together. And that's one of the things that employers really worry about, because it holds them accountable if they've got widespread violations of wage and hour laws or discrimination laws. So it really does give the employer a big protection against some of the strongest employment laws we have.
Yeah, and you feel so bad for them, and you'd hate to see them have to defend themselves against something like that, wouldn't you? My goodness.
That's right.
Oh, my goodness. Now, this also, I would imagine, has systemic effects that spread out long and far. What are some of the more specific pitfalls for workers in a mandatory arbitration process?
One of the big problems with mandatory arbitration is there's a lot of variation in who's going to be deciding your case. So it's no longer a judge who's, publicly confirmed and 12 jurors selected through our jury system. It's an arbitrator who's picked through this procedure, and there may be sort of discussions around who's going to be the arbitrator. But what we know from the research is there's a lot of variation. You could get a really good arbitrator who's a real, genuine neutral, but you could also get somebody who tends to favor employers. They could even be coming from a background representing employers as their regular job, and they could be doing this arbitration as a part-time business on the side, where one day they're the employer's counsel, and then the next day they're the arbitrator, and that's a real pitfall for workers, right? You don't get a real neutral, fair decision maker in those situations. And another big problem that we see is that arbitrators tend not to give as big damages to employees as juries would in the courts, and so that means that the employer can not worry about getting one of those big jury awards that we hear in cases where they've really done something bad.
Wow. We're speaking with Alexander Colvin, professor of conflict resolution at Cornell University's School of Industrial and Labor Relations, here today on the America's Democrats podcast. Alex, you and many other legal scholars have made the observation that this is a particular blow for women in the workplace. What is the impact of this decision on women employees?
One of the reasons it's a really big impact is because it deals with all of our laws, all our basic individual employment rights. And people don't always realize that. They think, well, surely this doesn't apply to civil rights. But unfortunately it does. And so if you have a gender discrimination claim, then you can no longer go to court to say, hey, I was discriminated against. And that includes sexual harassment claims. So we think of all the allegations that have been brought up as part of the Me Too movement. If those occur in a workplace where the workers have been required to sign these mandatory arbitration agreements, the plaintiffs, and they're predominantly women, are going to be no longer in court. They're going to be in these private arbitration procedures. And many of them include provisions that the victims of the sexual harassment who bring these claims can't even talk about it publicly. They're shut off from being able to communicate what happened to them. So it really has this danger of undermining our protections against sex-based discrimination in the workplace, against sexual harassment protections, and I think that really does have the danger of undermining women's rights in the workplace.
And it's not just women who stand to lose here. You've also observed that this decision can have a disproportionate effect on African American and Hispanic workers. How did you come to that conclusion?
Well, there's two kind of parts to it. One is that we know that about half of our employment law cases are actually cases of discrimination, as well as women workers. Major groups that are affected by discrimination in the workplace are African Americans and Hispanic Americans. They're often the plaintiffs in these cases. And so the claims that they bring to try and draw attention to and remedy discrimination in the workplace, those are the kinds of claims that are being funneled into arbitration. And it's particularly the case we find that lower wage workers are more likely to be covered by these mandatory arbitration agreements. And so, for example, African-American workers tend to be more likely to be employed in lower wage jobs, unfortunately. And so as a result, they're more likely to be covered by these mandatory arbitration agreements. And if they're trying to bring a claim for discrimination in the workplace, they're not as likely to be able to get into court. So it's really a kind of compounding effect that one of the groups that's most vulnerable in the workplace are having their rights in particular undermined this way.
It's interesting how it seems like we take a couple steps forward when it comes to labor relations, and then all of a sudden we have a decision like this and we take a significant step backwards. What are some of the other issues that are likely to be affected by this decision?
An area where we sort of made steps forward, I think, in employment rights is starting to have more stronger wage and hour laws. We saw the Fight for 15 campaign getting strengthened minimum wage laws. We're seeing some expansions of paid family leave in states like California and New York. And so we are seeing some increase of our individual employment rights, but we're seeing, these pushbacks against those rights. And this is a really good example of them because when you've got those rights to minimum wages, to leave, to overtime, you've got to somehow enforce them. And one of the basic ways we use to enforce them is bringing collective actions for groups of workers who were denied leaves, break time, all those basic rights we have. And this now undermines the enforcement of those rights.
We're speaking with Alexander Colvin, professor of conflict resolution at Cornell University's School of Industrial and Labor Relations. Alex, how does the decision fit into the broader context of workers' rights in America today?
I think what it shows is that even as we make some progress in certain areas, we face backlashes. So if you look over the last few decades, one of the broader trends has been fewer Americans have union representation in the workplace. That's declined over time. One of the ways we try to make up for that is expand these individual employment rights that everybody gets because we passed statutes in state legislatures and in Congress. But there's been a backlash to that. Employers and conservative groups have pushed back against those rights. Initially, you heard about things like tort reform, which is really a way to kind of undermine rights to bring claims in court. This is a version of that on steroids, where you really see this kind of backlash in the courts and by employers against the ability to enforce employment rights.
Now, for advocates and organizers for workers' rights, what are some next steps in the wake of this decision?
I think there's both immediate and broader long-term steps to take. Some of the immediate ones, certainly some of the employee advocates are out there trying to challenge these cases in the courts. It's difficult given the Supreme Court decisions, but there's certainly some creative tactics being used to kind of disrupt and protest against these arbitration provisions, filing lots of cases to kind of take up a lot of the employer time there. One thing that's, I think, creative is that some state governments have been looking at ways they can respond. Perhaps one of the most effective is something called PAGA, the Private Attorney General Act out in California, that allows basically private citizens to step in for the government and bring a kind of public claim, which isn't covered by arbitration. And there's now proposals in other states to bring in equivalents to the PAGA statute. So there's certainly creative things like that. I think the broader long-term response, though, really needs to be action at the federal level. In Congress, there's some statutes that would change the Federal Arbitration Act that would reverse some of these rules. And certainly, if Congress control changes, this could be brought forward. And then ultimately, the really big long-term thing is that this is another consequence of the Gorsuch appointment. This was another 5-4 decision where the 5 conservative justices, again, kind of got together to bring forward a conservative economic agenda. If we had Merrick Garland on the court, I think it would have been 5-4 decision the other way. So this is a really good example of, once again, how that control of the Supreme Court matters a lot.
So for now, it's up to the states to kind of help out labor.
Absolutely. States are where most of the action, the positive action, is going on today.
Okay. Alexander Colvin, professor of conflict resolution at Cornell University's School of Industrial and Labor Relations, joining us today on the America's Democrats podcast. Alex, thank you so much for your time with us today, and we do appreciate it and hope you can join us again soon.
You're welcome. I'm glad to.
Fantastic. And this is the America's Democrats podcast, the weekly podcast for stand-up Democrats. We want you to sit back and listen to this americasdemocrats.org podcast, a project of 21st Century Democrats. But we need you to stand up and fight. Do you want to get involved and help get our party back to its roots and to success at the ballot box? You can make your contribution to help us keep this show going and to elect Democrats who will stand up for democratic principles. Go to americasdemocrats.org and click on Donate at the top of the page.
This Social Security measure, I believe that we must pass legislation to provide medical care.
This is our tradition. When our grandparents came to America, it was the Democratic Party which said, welcome. It was the Democratic Party, the party of Roosevelt and Truman and Kennedy and others, who said that America belonged to all its people, not just a handful of the rich or a few giant corporations. That's why great leaders like FDR fought so hard for Social Security, and why JFK stood up to the insurance companies and their Republican allies to get Medicare. It's not just one thing or one time in one place. It's about a whole history of standing up to the Republicans and saying someone has to be on the side of regular working people in America. Whether it's defending Social Security or just the way your loved ones are treated on the job. That's what the Democratic Party is all about. And that's why this message has been brought to you by the Democratic Party. Working people like you and me.
Paid for by 21st Century Democrats. Not authorized by any candidate or candidates committee. This is the America's Democrats podcast, the weekly podcast for stand-up Democrats. Coming up next, the long history of denying felons the right to vote and why it matters. But first, we turn to Jim Hightower, America's #1 populist, for his common sense commentary.
Today's corporate captains like to think of themselves not as mere business people, but as modern society's innovative geniuses. But innovation for what purpose? After all, some of society's most inventive minds are flim-flammers, Ponzi schemers, gamers, embezzlers, thieves. Sure enough, too much innovation coming out of corporate suites these days amounts to shameless schemes to dupe and rip off rank-and-file workers. The latest one is a hustle called gamification, an attempt by such giants as T-Mobile and Walt Disney to give game-like, quote, psychological prizes to employees, rather than giving pay raises or cash bonuses. As the honchos of United Airlines learned, however, not everyone bites the corporate bait. United recently announced a new fun game for employees. Rather than giving standard bonus payments this year, bosses were creating a dazzling sweepstakes lottery with such wow prizes as luxury cars and $100,000 in cash. But the sizzle quickly fizzled, as United's 90,000 workers realized that more than 99% of them would get zero. United had hoped the game would create, quote, excitement among the rank and file, but instead it created resentment. Workers, naturally preferring bonus cash to bogus corporate excitement, rebelled with such fury that United is now reconsidering the switch. That case aside, however, the corporate push to replace real pay with cheap psychic income is on the rise. More corporations are even hiring chief behavioral officers to analyze reams of personal data on employees to devise non-cash ways to motivate them. This is Jim Hightower saying, what we have here is the deterioration of executive ethics to the point that openly gaming and cheating America's workaday majority is considered fair play.
Need an antidote to the progressive blues? Want some good news about how grassroots folks are rebelling against the corporate powers and winning? Well, here's an easy-to-swallow pill for you, the Hightower Lowdown. Hightower's monthly newsletter will give you the lowdown, even as it lifts you up. It's 4 pages a month, jam-packed with facts you can use, actions you can take, and Jim's own Texas humor, all for only $15 a year. To become a lowdowner, go to hightowerlowdown.org.
This is the America's Democrats podcast, the weekly podcast for stand-up Democrats. Nicole Porter is an advocate for eliminating racial disparities in the criminal justice system. She says the practice of denying felons the right to vote has deep historical roots designed to limit the vote to wealthy and white elites. And we say hello to Nicole Porter, Director of Advocacy at the Sentencing Project, where she manages state and local efforts on sentencing reform, voting rights, and eliminating racial disparities in the criminal justice system. Nicole Porter, thank you so much for joining us today on the America's Democrats podcast.
Thank you for having me. Glad to join you.
Oh, and it's certainly our pleasure to have you with us. We asked you to come on the program today to talk about felony disenfranchisement. That's a term that may be unfamiliar to some listeners. What does it mean?
Well, it means the loss of voting rights due to a felony conviction. Nationally, there are more than 6 million residents who have lost their voting rights due to that felony conviction. This includes the 1.5 million person sentenced to state prison or federal prison, and the more than estimated 3 million persons who are disenfranchised due to state laws that restrict voting rights even after they've completed their sentence. So, felon disenfranchisement and rights restoration practices vary widely across states and are subject to the political climate and leadership within a state, which has led some states to fluctuate between reform and actually regressing on disenfranchisement policies, so restricting rights for residents if they have a felony conviction.
And, many people are surprised to learn that someone can actually be deprived of their right to vote. How is it even possible to deny a felon of their basic right, which is at the core of our democracy?
This country was rooted in principles related to participatory democracy. However, the history of felon disenfranchisement actually goes back to the founding of the country. English colonialists brought the practice to North America through the common law practice of civil death that established a range of criminal penalties, including a civil death or a loss of civic rights for people who broke the social contract, including breaking criminal laws. And that practice continued with the evolution of participatory democracy throughout the, advancement of the country. So after the American Revolution, states began codifying disenfranchisement provisions along with their state constitutions. And following the Civil War, many states instituted felony disenfranchisement policies by 1869. So 29 states had enacted such laws, and one researcher argues that the elimination of a property test as a voting qualification may help explain the popularity of felony disenfranchisement policies and how felony disenfranchisement served as a proxy for ensuring that only wealthy white elites could participate in representative democracy in the United States.
Now, at the individual level, what's the impact of losing your right to vote?
Well, many people who work in criminal justice reform and policy sort of scoff at the idea that focusing on felony disenfranchising policy should be a focus of reform or should be a focus of social policy. But in many ways, it's a reflection of how democratic our country is. And, folks who observe American democracy, who care about the authentic and genuine implementation of it, should care about the residents who are most marginalized from it. And for people who are individuals, I've heard and learned from formerly incarcerated activists who are incredibly moved and politicized around working for their right to vote and supporting the enfranchisement of other residents who have a prior criminal history, a prior felony conviction history, and have lost their right to vote. I've seen the loss of voting rights motivate residents around politics, ensuring the franchise gets expanded to residents with those felony conviction histories, and also shoring up their full participation in civic life long after they've completed their sentence and have satisfied their punishment to the court and to their community through restitution and other means. So as an advocate who works in this area, it's an incredibly moving area of reform and grassroots activism, and one that really inspires directly impacted people to work towards criminal justice reform and ensure that the franchise is extended to all residents in this country, including people who may have at one point, come in contact with the justice system, but now want to be good citizens and good neighbors by fully participating in American democracy.
Your organization documents dramatic growth in disenfranchisement over the past several decades. What accounts for this growth?
Well, the number of people who are justice involved has grown in terms of the number of people in prison and jail, and the number of people who have prior criminal histories has grown. And so because that curve around and the impact of people in the criminal justice system has grown, the number of people impacted by criminal justice policies, even long after they've completed their sentence, has grown. So the number of people disenfranchised today numbers over 6 million. That has increased from more than 3.3 million over 20 years ago in the mid-90s to as many as 5.4 million in 2004. And that mirrors the growth in the general prison population. And so, the United States has the highest rate of incarceration in the world, including amongst other Western democracies. And that is in addition to the number of people who are impacted by justice involvement long after they've completed their sentence. So there are some estimates that 19 million individuals, of course that's much higher than the 6.1 million individuals who are disenfranchised, but there are some estimates that 19 million people have a prior felony conviction and have at some point either been inside of a prison or jail or at least been justice involved to where they have that felony conviction.
We're speaking with Nicole Porter, Director of Advocacy at the Sentencing Project, where she manages state and local efforts on sentencing reform, voting rights, and eliminating racial disparities in the criminal justice system. Nicole, how does this issue have a disproportionate effect on African Americans?
Well, nationwide, 1 in every 13 black adults cannot vote as a result of a felony conviction. And in 4 states, Florida, Kentucky, Tennessee, and Virginia, more than 1 in 5 black adults is disenfranchised. Denying the right to vote to an entire class of residents is deeply problematic to participatory democracy, and this racial disproportionality is representative of a range of policies that has sought to marginalize black residents from the franchise, ranging from policies in post-Reconstruction America following the Civil War to the Jim Crow era. And, many activist scholars compare this era of mass incarceration that we're living through to an extension of the eras that sought to marginalize black residents since the founding of this country, including an extension of Jim Crow era policy. So, for example, Michelle Alexander, who many of your listeners may have heard of, wrote the book The New Jim Crow, and the policies that seek to disenfranchise all residents but have this significant impact on black residents is in many ways compared to Jim Crow policies of an era, before that predates this era of mass incarceration that we're living through today.
Nicole Porter, Director of Advocacy at the Sentencing Project, where she manages the state and local efforts on sentencing reform, voting rights, and eliminating racial disparities in the criminal justice system. Nicole, thank you so much for joining us today on America's Democrats podcast. We look forward to getting an update down the road and hearing back from you.
Thank you so much for having me, and I hope that your listeners continue to work to expand the franchise and invite them to get in touch with us at the Sentencing Project if they want to look into it more.
And that's sentencingproject.org if you want to find out some more information and see what you can do to get on board. Nicole, thank you again for your time. We look forward to hearing from you again.
Thank you.
This is the America's Democrats podcast, the weekly podcast for stand-up Democrats. We want you to sit back and listen, but we need you to stand up and fight. Help get our party back to its roots and to success at the ballot box. Make your contribution to keep the AmericasDemocrats.org podcast, a project of 21st Century Democrats, on the air, and help elect stand-up Democrats. Go to AmericasDemocrats.org and click on Donate at the top of the page. This is the America's Democrats podcast, the weekly podcast for stand-up Democrats. And now Bill Press talks with Sam Baker of Axios on the latest battle over affordable health care that could jeopardize legal protections on pre-existing medical conditions.
Lots of action on the Supreme Court front and lots of action on the health care front. Sam Baker from Axios keeps on top of that and joins us to bring us up to date. Hi, Sam.
Hey there.
Good to see you.
You too.
We were just talking a little bit about this decision yesterday on the Supreme Court with Ohio. Pretty significant decision in terms of this.
Yes.
All these efforts about voter suppression that we've seen around the country.
Yeah. Ohio is the most aggressive state in terms of purging its voter rolls. It's not unusual for states to have some kind of, after so many years, or some mechanism to try to sometimes legitimately clear out people who haven't lived there.
Right.
I'm probably still registered to vote in Kentucky, and if they want to, I haven't lived there since I was 18. So if they want to get me off the rolls, that's sort of okay. But like everything else related to voting now, it is all red states have realized this can be a weapon to keep people from voting who we don't want to vote, that there's a very strong, credible accusation that's what's going on in Ohio, and that'll happen more now.
What is the reality of voter fraud?
Almost none. There is, I mean, I think in 2016 they found fewer than 10 cases, some of whom were voting for Trump.
Yeah. About 300 million Americans, or maybe 200 million registered or whatever.
There's just it's a theoretical problem, but there's no evidence yet to suggest that it is a real problem, really hardly at all, much less one that is significant enough to actually affect elections.
Right. And part of this was triggered, as you indicated, by the finding, and we heard this in 2016, that there were millions of people who, or maybe I think millions probably, nationwide, who were registered in more than one state.
Right.
Because they had moved. And when you move, like I have moved, when I moved here from California, I didn't take our name off the I didn't call up the...
Right. Who would think to do that?
No, you don't do that. You don't call the Secretary of State and say, just want you to know.
Right.
I'm moving, but when you get to the new place, you register to vote, and that's where you vote.
Right.
And that other thing just sort of hangs out there, right?
Right.
It doesn't mean that you're voting in more than one state.
Right. No, it sounds nefarious when you say, people are registered to vote in multiple states.
Right.
Like, I don't know.
Yeah.
From who unregisters to vote, you just sort of assume. But,
I think as I recall, Steve Bannon was registered to vote in more than one state.
I think that's right.
Yeah.
Aren't we all?
So in Ohio, but they would send you the Constitution prohibits dropping people just because they don't vote. But that was the issue in front of the Supreme Court, as I understand it.
It's a federal law, not the Constitution.
Federal law, sorry.
Yes.
Okay. But then Samuel Alito in the majority decision said, no, Ohio doesn't just do that, though. They send you a postcard.
Right. That's really just what he says, is that people aren't being dropped because they didn't vote, because that would be illegal.
Yeah.
People are being dropped because they didn't vote, and they didn't return a postcard in the mail, which, I can tell you right now, inside the front door of my apartment is a lot of mail accumulated over months, some of it from the city of the District of Columbia. That's a really common offense, if you're going to call it an offense.
Right. That you've never looked at.
Right.
Or people have never looked at.
Right.
And again, particularly for younger people, we were saying this earlier, I mean, getting snail mail, right? I mean, it's just not the way they communicate.
Right. And it's, tell us if you've moved, and if you haven't, you think, well, this must be fine, right? I didn't change anything. So it's
right. But you said something important earlier, I think. There will be more of this now after this is basically a green light to other states.
Yes, you can go. So Ohio was the most aggressive in terms of doing this. So now every red state knows you can go at least as far as Ohio. Someone will surely try to push it further, and we'll be back here talking about whether that was constitutional.
Now, this was a 5-4 decision, and the classic 5, as you can imagine. A little different decision last week on the cake.
Yes.
It was 7-2, wasn't it?
It was. It also didn't say much.
Okay.
It was.
So this is a cake again. Yeah. This is the case, just to remind all of our listeners and viewers, out of Colorado, right?
Yes. So it was
the wedding cake.
Exactly. A same-sex couple went into a cake shop. They said, we want a custom-made cake for our wedding. The owner of the cake shop said, I am a Christian. I don't believe in same-sex marriage. I will not bake you a cake. And so that collision of his religious rights and their rights as a same-sex couple collided in the courts, well, first in the Colorado Civil Rights Commission and then all the way up to the Supreme Court. And what the Supreme Court basically said was, look, same-sex marriage wasn't legal in Colorado at the time. When it was before that first Civil Rights Commission, some of the commissioners seemed pretty dismissive of Christianity and just sort of acted like he can't possibly believe this. So we don't think he got a fair shake. So he wins. But, now same-sex marriage is legal nationwide. They very explicitly said the next baker might not win. Just because this guy could do this a couple of years ago when the law was different does not mean we are saying that will be the law forever. So, I think that is pretty narrow on the merits, right? There was a lot of evidence that the guy didn't quite get a fair shake, even if the decision would have come out the same way. that he didn't really get a fair hearing before the Civil Rights Commission, and that's why 2 liberal justices were willing to say, okay, fine.
But to me, it was pretty disturbing because some people will take that decision and say, look, I don't have to serve them a pizza, or, I don't have to wash their car, or I don't have to sell them a suit or whatever, because the Supreme Court has ruled that this baker can get away with refusing to make a wedding cake for this couple.
I mean, I think you've seen the court and really Justice Kennedy in a lot of, as some new piece of same-sex marriage or same-sex couples' rights has come up, they've always just sort of put their, sort of signaled, we're on the side of the same-sex couples, but we're not going all the way there. When they struck down DOMA in, what year was that? 2012, maybe, the federal ban on same-sex marriage before before they said states can't do it either. They could have gone all the way then. But just sort of said, we're, on their side, but we're going to let this build up in the lower courts, let sort of more judges reach their own conclusions, flesh out the law, and then eventually it'll get back to us. And we're kind of telling you where we're going to fall, but not really.
So one step at a time.
Exactly.
Yeah. It's still pending, and by the end of June, Supreme Court usually wraps up its work for the year, right?
And there's a lot left.
Yeah, I was just going to say,
it's going to be a really insane couple of weeks.
They have some big decisions coming down, including reapportionment.
Yes.
What else?
Well, that's a really big one to the process of elections. That will be really huge.
That's Wisconsin?
Yes. And that the basic question there is when you do gerrymandering, it's well established that it's illegal to gerrymander districts for racial reasons. But the question here is, can it ever be unconstitutional to do it just for political reasons? If you say we're just Republicans and we control everything and we want to keep controlling everything, can you ever take that too far? So that's just a really interesting threshold question for the next census and, every 10 years after that.
Right.
There's also the travel ban still coming.
Oh, they've got the travel. Yeah.
Yep.
Whoa.
Which I think they probably will uphold based on the oral arguments. They've got a really interesting case. This is not as political, but about whether police can get the location of your cell phone without a warrant, which is just it's interesting because we keep our phones with us all the time now, and the court's precedents aren't really up to snuff for that. They're based on when you would make a phone call on a landline, and now it's a record of your every move and everything you've ever looked up on the internet. I think
But isn't it just a fact that everybody can know where our cell phone is at any one time? That's built into the cell phone.
Well, it's the without a warrant part that's a big deal. Should the police need to, when they go to the cell phone company and say, we want to know where Bill was for every second of Tuesday, should they have to demonstrate probable cause that you were doing something untoward, or can they just go?
I have an answer. Yes is the answer. Yes, they should.
On me?
Well, on anybody, not just you, but especially you.
I wouldn't be surprised if that's what they say during arguments. They were, they're all pretty old, but they were pretty well aware. This technology is just different than anything we've dealt with before, and they just sort of seemed like people who've recognized they needed to pump the brakes. If that makes sense.
How do they get it? By the way, they just go to Apple and say
they don't go to Apple. They go to AT&T or Verizon or whoever it is.
Yeah,
because everything you do on your phone is technically their data, not yours.
Right. Yeah. There's no way that they're going to rule otherwise on that one.
It's that's what I say. It's not as overtly political, but we all have a lot on the line.
Right. Now, meanwhile, just changing directions here to get into the Affordable Care Act, all the efforts made to repeal, 3 efforts as I recall, through the Congress, repeal and maybe replace or not even replace, were not successful. So now it's chipping away through administrative, right, and executive actions.
And in the courts.
Right. Which brings us to this latest move on the part of the administration.
Yes.
Which really are aimed at some of the most popular parts of the Affordable Care Act.
Yes.
Guaranteed
coverage for people with pre-existing conditions. Like the one thing that everybody knows about the Affordable Care Act.
Right.
The one thing that everybody supports about the Affordable Care Act.
That you cannot deny somebody the right to buy insurance, or just simply because they have a pre-existing condition.
Right.
And a lot of people do, don't they?
Yes.
I mean,
millions of Americans have pre-existing conditions.
It's almost, if you don't have a pre-existing condition, right?
Yeah.
You're the exception rather than the rule.
Yeah.
If you don't have one. Right.
And so there's two provisions here. One that says insurance companies cannot just refuse to sell you a plan. And then the other one says they can't charge you more because of your pre-existing condition. Mm-hmm. So they can't come back and say, well, all right, we'll cover you, but for $1 million.
Right. And these, so how did this come about? Are these in the courts? Are they being challenged? Or
they are. It's sort of a weak argument, and so it's a complicated argument. But it all goes back to the individual mandate, which Republicans said they repealed as part of the tax bill.
Right.
What they actually did was they removed they changed the penalty to $0. So the way the mandate's written, it says you have to have insurance or pay a penalty. When the Supreme Court upheld the mandate in 2012, they said, sure, Congress can make you pay a penalty. That was the whole thing about it being a tax. But they did not uphold the, half of the sentence that says you have to buy insurance. They just upheld the penalty. So now Congress comes in and changes the penalty to $0. And Texas, of course it's Texas, says, hey, that other thing that says you have to buy insurance is still on the books. Court never upheld that. The thing they upheld is gone, but so it's unconstitutional. So now they're saying that because of the way the individual mandate was sort of repealed, the whole law is unconstitutional. Then the Trump administration, DOJ, comes in and says, we agree that the individual mandate is unconstitutional now, which is a big thing for them to say anyway, because their job is usually to defend federal law.
Right.
And we don't think the whole Affordable Care Act has to fall along with it, but guaranteed coverage for people with pre-existing conditions does. So this was a choice that that DOJ made. They could have just said, no, the mandate's fine. This is ridiculous. They could have said, mandate's unconstitutional, but you can just slice that out and leave the rest. They could have said anything, and they chose to say, this is the piece that has to fall.
Well, now, so in this midterm election year, doesn't this, as you pointed out, this is one of the most, maybe the most popular part of the Affordable Care Act. It's the one thing that everybody agrees that you should not
and understands.
Yeah.
That law is so complicated, but they still have to cover you.
Right.
Okay. I get that.
So just to make sure I understand, so the Trump administration went out of its way to put themselves on the side of Texas in this case, right?
Yes.
They didn't have to get involved. As you say, usually their job is defending federal law.
Yeah.
This is agreeing with the state to overturn federal law on the most popular provision of the Affordable Care Act.
Right.
Why? In this election year would they do that?
That's a great question. I mean, you did see, too, I think it was 3 career DOJ lawyers left the case right before this filing came out. So we kind of knew, that they're going to do, they're going to go all the way here, and it's political lawyers that took it over, which makes sense in terms of the decision to change their position.
So these 3 lawyers, just so people understand, refused to put their names on this case, right? They thought it was so bad.
Yeah. Which is very rare.
Yeah.
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 There's nothing that could happen for Democrats in the midterms that would change this. It's a lawsuit. DOJ is not up in the midterms. They can keep doing whatever they want. And this lawsuit's already in progress. It's in Texas, conservative judge. But all the same, for the administration to reopen this debate about pre-existing conditions. And, it's an accurate hit now for Democrats to say the Trump administration wants to take away coverage for pre-existing conditions. Yeah, that's the position they've taken.
Right.
It's not like 2 or 3 steps removed. It's just what they said they want to do.
Yeah.
Why you would reopen that in a midterm cycle that Democrats already want to make all about health care just makes no sense.
The Wall Street Journal NBC News poll last week, we talked about it here. One of the things that struck me about it is it was the matchup of would you rather have Democrats or Republicans in control of Congress? Would Would you vote for more likely to vote for somebody who's going to stand up to Donald Trump or go along with Donald Trump? But the other question they ask is, what's the most important issue facing the country? And number one, healthcare.
Yeah.
Turned out it was healthcare over jobs in the economy.
Yeah.
It really is kind of amazing how Democrats might not have won the election, but they've certainly won this issue of healthcare, right? Like before Barack Obama was president, everything was fine. Nobody cared, right? Like, I shouldn't say nobody cared, but like it wasn't a priority to get healthcare fixed in this country. And now, because of Obamacare, because of the ACA, try taking healthcare from someone who has that. And we saw what happened. The Republicans saw what happened. And for them to double down on this seems unwise at best.
Well, yeah, I think politically unwise, as long as Democrats are in the position of taking advantage of this and making sure that people understand what's going on.
Right.
And who's doing it, who's responsible.
Yeah, well, and that's why I get back to it's such a simple and easily understood part of the law. You know, Obamacare is really complicated.
Right.
And it also seems really complicated. And to get in there and say, well, you know, they're doing this thing that's going to cause insurers to raise their premiums, so we got to make a payment over here. And people just kind of, why are you doing this?
Right.
But this is just such a simple, you know, almost moral argument.
That's what I was going to say. I mean, at best, it's unwise. At worst, it's just immoral.
Mm-hmm. No, and you think about the most popular provisions of Obamacare, right? This is one.
Yes.
The other was kids being able to stay on their parents' plan until they're 26.
Yeah.
Does that still exist?
It does.
Okay.
It does.
They haven't gone after that yet?
Not yet.
Okay. I'm just trying to think what else might have been.
Medicaid expansion's actually.
Medicaid expansion.
It plays as really controversial in politics, but on the ground, it's pretty popular.
Right. And particularly Virginia coming on board now.
Yeah.
440,000 people added. And Ohio, we talked about Ohio just a little earlier, but Ohio's under John Kasich did expand Medicaid. He's one of the few Republican governors, red state governors, who bucked the trend.
I think one of the things you just said, Sam, was really telling about where we are. It plays well politically, but on the ground, it's a totally different story. I think that's the story of Obamacare, right? Like, you have people who are in Congress today who ran almost exclusively on repealing Obamacare. And when it came down to actually repealing Obamacare, when you had when Republicans had a supermajority, they couldn't do it because it's just on the ground. It's too popular.
And the specific thing that always tripped them up was coverage for people with pre-existing conditions. You know, because you start to take away the individual mandate. All right, then how do you pay to cover sick people? You start messing with the subsidies. You know, it's a complicated law, but that's because it's trying to use the free market and private insurance to cover people who are expensive to cover. And, you know, you pull a lever over here and really soon you're starting to chip away at that sort of core promise. And that was something that congressional Republicans, to your point, Peter, already decided they didn't want to do. Right. They already got right up to it and said, well, we're not doing that.
Yeah.
But, you know, I think these three attorneys who pulled themselves off the case is very instructive. I had a chance to interview, I think, one of the sharpest legal minds in the country, for sure, Jeff Toobin from CNN and New Yorker, last evening over here at the Hill Center. And we were talking about this, and one of the points he made was, he said, can you imagine these three? So these are career professional attorneys, been with the DOJ, you know, maybe decades, right? Republican, Democratic presidents. They're just there doing their job, right? And they're asked to go out and doing their job, representing the federal government, and take health care away, to deny people who have some pre-existing condition the right to buy health insurance. I mean, is that really the way you want to be remembered, right? You want that part of your legacy, really, if you're a dedicated attorney? No, these three people said, no, we are not going to do that. It goes against everything we believe in. And it wasn't a partisan political thing. It was just a human decency argument, right?
One thing people need to understand about both lawyers and civil servants in the federal government is your job is to execute whatever the thing is that the political people decide. If you're a civil servant, and if you're a lawyer, it's to represent your client. So to be a longtime litigator for the Justice Department, you've seen administrations change. And you've said, all right,
we
were over here, now we're over here. I will do my best job to make the best argument for my client, which is the federal government. And that's the job. And that's what a good lawyer does. So, it's not just they were asked to sort of take a conservative position, because that comes with the job.
Yeah.
It comes with both layers of the job, being a civil servant and being a lawyer. So that's what sort of makes it so incredible for these lawyers to get off the case.
Right.
Is,
back to this case of Ohio yesterday. What are we learning in general? What are we learning about Neil Gorsuch? He's not going to be any David Souter, is he?
No. For Trump's purposes, it was a good pick. He is very conservative. He has a lot to say, which is not surprising. He had a lot to say on the appeals courts. I think if you look at it as a seat that could have been Merrick Garland's, it's really shocking. If you look at it as a seat that was Antonin Scalia's, it's kind of stayed the same. You have a really talkative, really conservative guy in that seat.
Right.
And you will for decades.
And so Mitch McConnell's gambit of denying Merrick Garland a hearing for a whole year paid off.
Yeah.
Yeah. And he's the one I think who gets, if you want to give credit or blame, not Donald Trump. It's more Mitch McConnell's choice than anyone. Hey, Sam, it's great to see you. Thanks so much. You can follow Sam at Axios, of course, axios.com.
That's all for the America's Democrats podcast. Thank you to all who made today's show possible. Alexander Colvin, Nicole Porter, and the entire Bill Press team. And thank you for listening. If you liked what you heard, please get involved in our efforts to keep this show going and to elect Democrats who are bringing the party back to its roots. Go to americasdemocrats.org and click on Donate at the top of the page. And be sure to find 21st Century Democrats on Facebook and Twitter. And leave us a review on your favorite podcast app. For the America's Democrats podcast, I'm your host, Jim Cuddy. We want you to sit back and listen, but we need you to stand up and fight. Join us. Support the americasdemocrats.org podcast, a project of 21st Century Democrats, and help elect Democrats who will stand up for democratic principles with your contribution today. Go to americasdemocrats.org and click on Donate at the top of the page.